In Module 1, we deal with two items, secure transactions and negotiable instruments. So first we're going to look at secure transactions and the specific problems that were assigned for this section. Secure transactions follows Article 9 of the UCC, which is the Uniform Commercial Code. We will look at 13 specific problems as indicated in the module readings and instructions. These problems and the text associated with them are found in Unit 18 of your text, pages 267 to 294. When we look at problem 1, it's asking about the applicability of Uniform Commercial Code Article 9, and specifically these items are found on page 268. In order to answer this question, which is asking you which of the following is included within the scope of the Secured Transactions article of the UCC, you need to understand the definitions of these items. If you go to page 268, there's a very long paragraph which talks about which items fall under Uniform Commercial Code Article 9 and which do not. So if you look at B and C, they are specifically not listed in this paragraph. D is a type of trick question because you do see chattel paper and it's actually in bold print. However, this is not talking specifically about chattel paper in and of itself. It's talking about the sale of chattel paper as a part of a sale of a business. So you need to look very specifically at what they're saying because this is really trying to trick you. So the only one that falls under this category is item A, accounts receivables, and those are found about 2/3 of the way down that paragraph. Okay, problem 2 deals with Article 9-102 definitions. And in this section of the UCC, it classifies goods into 4 categories. Consumer goods, which are those used or bought for use primarily for personal, family, or household purposes. An example of this would be like a refrigerator. The second item is inventory. Inventory consists of goods leased by a person as lessor, held for sale or lease, furnished under contracts of services, or consisting of raw materials, work in process, or materials used or consumed in a business. The next is farm products, and those are crops, livestock, supplies used or produced in farming operations, or products of crops or livestock in their unmanufactured state. These items must be in the hands of one engaged in farming operations. If goods are farm products, they cannot be equipment or inventory. And the last item is equipment, and it means goods other than inventory, farm products, and consumer goods. So if the item doesn't fall under the other 3 categories, then it would fall under equipment. The next problem is problem 5, and it deals with conveying a security interest. If you click on the conveying word, it will give you the definition in Black's Law Dictionary. We'll look briefly at it. Convey means to pass or transmit the title to property from one to another, to transfer property or the title to property by deed or instrument under seal. Okay, so that will give you the definition. And the question is really asking, when does attachment occur with inventory, which is one of the goods items that we just looked at? For attachment to occur, 3 things must happen. The collateral is in the possession of the secured party, also known here as the debtor, which is Gifford. Second, value has been given. And third, the debtor has rights or the ability to transfer rights in the collateral. If we look specifically at the question, it says Lombard Inc. manufactures exclusive designer apparel. It sells through franchised clothing stores on consignment, retaining a security interest in the goods. Gifford is one of Lombard's franchisees pursuant to a detailed contract signed by both Lombard and Gifford. For security interest to be valid against Gifford with respect to the designer apparel in Gifford's possession, Lombard, and it gives you 4 options. So basically, Lombard manufactures clothing and sells it to franchised operations. For example, let's say Levi is the same as Lombard, and they sell to a company like Belk's, which is a franchised operation. Whenever Levi delivers a set of clothing or items of clothing to one of the franchise operations, let's say Belk's, or in this case they're talking about Gifford in Milledgeville, they retain a security interest if the 3 things that are listed for attachment has occurred. The collateral is in the possession of the secured party. So, has Gifford take possession of the clothing? In this case, yes. Has value been given? Certainly. Once the clothing passes to Gifford, value has been given because there is value in the clothing and apparel that was delivered by Lombard. And 3, does the debtor have the rights or the ability to transfer rights in the collateral? In this case, Gifford holds this clothing, or Belks, or whoever you want to talk about, and they have the right or the ability to transfer rights in the collateral, which means that they have the ability to sell that clothing. So even though they haven't paid for it yet, they have possession of it and they have the right to sell it. They then collect that money, and that money goes to be paid to pay down the debt with Lombard. In the event that Gifford doesn't pay, then Lombard has the right to take the money that Gifford has or take the remaining clothing items that are in his possession with respect to inventory. Okay, so next we're looking at problem 10, and again we're dealing with the conveying of a security interest. Specifically on page 273, it talks about parties' rights and duties when the secured party holds the collateral. This question reads, when collateral covered under the Secured Transactions article of the UCC is in the secured party's possession, and there are 4 options. If you look at B is incorrect because the secured party must keep the collateral identifiable, but fungible collateral may be commingled. So basically it's saying that other collateral or other inventory that's not related to the specific item that was sold can be commingled. They don't have to keep it separate. C is incorrect because reasonable expenses including insurance and taxes are chargeable to the debtor and are secured by the collateral. And D is incorrect because the secured party may use or operate the collateral to preserve it or its value as permitted by a court or except in the case of consumer goods pursuant to an agreement with the debtor. So therefore, item A is correct. The risk of accidental loss is on the debtor to the extent of any deficiency in any effective insurance coverage. So basically, once the items are delivered to the secured party, the debtor, they have the responsibility to use it in the appropriate way, to use it in the way that it's intended, keep it safe. But in the event that there is a loss, even due to no fault of the secured party, they're responsible for still covering those expenses and paying back the original creditor. Okay, next we're looking at problem 13 in the issue of perfection. To look at the definition of perfection, we're using the process of putting the world on notice of the security interest in order to make the secured party's rights fully enforceable. So basically we're saying that the purpose of perfection is to let everyone else know that the person or company who is holding these items does not have true title to it, in the fact that their security interest is held by another party, which is the creditor. So the question is, what does perfection do for the creditor or secured party? Specifically, it states, what is the result of perfecting a security interest? Perfection of a security interest maximizes the secured party's rights with respect to the collateral. Although perfection will not give the secured party priority over all subsequent secured parties, it will give priority over all unperfected interest and over most subsequent secured interests. So therefore, answer A is incorrect because perfection is not required to enforce the secured party's rights against the debtor. Answer B is incorrect because perfection will generally lapse within an appropriate period after the collateral is removed to another state. And that goes down a completely different path than what we're talking about. And answer C is incorrect because perfection gives the second party priority over all unperfected creditors and some but not all subsequent secured parties. And we'll look at that a little bit closely in another question. So therefore answer D is correct. What is the result of perfecting a security interest? The secured party has priority in the collateral over most creditors who subsequently acquire a security interest in the same collateral. Okay, problem 14 also deals with perfection, and the question is asking, a secured creditor wants to file a financing statement to perfect its security interest. Under the UCC Secure Transaction article, which is Article 9, which of the following must be included in the financing statement? And the 3 requirements for a financing statement: it must have the name of the debtor, the name of the secured party or representative, and it must indicate the collateral covered. And by doing so, a financing statement that covers as extracted collateral or timber to be cut, or that covers goods that are to be fixtures, must include additional information. For example, a description of the real property to which the collateral relates. If the collateral is growing crops, uncut timber, or unextracted minerals, the financing statement must also describe the pertinent real estate. So answer B is incorrect. The inclusion of an after-acquired property provision is not required for the financing statement to be effective. And answer C is incorrect because the inclusion of the creditor's signature is not required for the financing statement to be effective. And answer D is incorrect because the inclusion of the collateral's location is not required for the financing statement to be effective. When it indicates a collateral covered and the collateral covered is a part of something else, which is a set of real property, it must include some indication of the address or the description of the real property, location of the real property, possibly directions. So if it's not obviously someplace or can't be found easily, then the indication of the collateral covered must include some type of description of where that might be located. Okay, problem 17 is dealing with the perfection of security interest upon attachment. The question reads, Work Inc. manufactures and sells household appliances on credit directly to wholesalers, retailers, and consumers. Work can perfect its security interest in the appliances without having to file a financing statement or take possession of the appliance if the sale is made by Work to. And the question is asking you about retailers, wholesalers that then sell to distributors for resale, consumers, and wholesalers that then sell to buyers in the ordinary course of business. And there's automatic perfection when the purchase money security interest is in consumer goods. Now there is some exceptions in title states or states which have differing statutes or regulations, but for this purpose we're looking at if you have a purchase money security interest in a consumer good such as a refrigerator or a washer or dryer, then that makes answer C correct. So consumers. So he doesn't have to do anything else to perfect his security interest if he is selling to consumers. Answer A is incorrect because goods held by retailers are inventory, and inventory is not an exception to the filing requirement, and Work must file a financing statement to perfect a security interest in collateral held by retailers. Answer B is incorrect because goods held by wholesalers are inventory, and as we just said, inventory is not an exception to the filing requirement. And answer D is incorrect because Work must file regardless of the wholesaler's disposition of the inventory. So again, answer C is correct because there's an automatic perfection when you sell consumer goods under purchase money security interest. Okay, problem 21 appears to be fairly complicated, and they're just using some terminology that you're not familiar with. It deals with perfection and attachment. And the question states, Tawny Manufacturing approached the worldwide lenders for a loan of $50,000 to purchase a vital component it used in its manufacturing process. Worldwide decided to grant the loan, but only if Tawny would agree to a field warehousing arrangement. Pursuant to their understanding, Worldwide paid for the purchase of the components, took a negotiable bill of lading for them, and surrendered the bill of lading in exchange for negotiable warehouse receipts issued by the bonded warehouse company that had established a field warehouse in Tawny's storage facility. Worldwide did not file a financing statement. Under the circumstances, Worldwide would, and there are 4 options. So what it's saying is Worldwide gave the loan for the money to Tawny to purchase this item that it needed for its manufacturing process. Through a negotiable bill of lading, it's saying that it's not taking a security interest in the actual item that it manufactured and sold to Tawny, but is taking an interest in the goods that are manufactured as a result of this part going into Tawny's manufacturing process. So Tawny takes the part, puts it in its manufacturing process, and as a result it manufactures goods. These goods go into a warehouse. So essentially what Worldwide is doing is taking interest in the goods instead of the actual item that it sold to Tawny. So the requirements of attachment have been satisfied. So for attachment, 3 things must happen. The collateral is in the possession of a secured party in the form of negotiable documents of title, which is the field warehouse. Value has been given, and the debtor has rights or the ability to transfer rights in the collateral. So the requirements of attachment again have been satisfied. Value was given, the debtor had rights in the collateral, and the secured party had possession of the collateral. When the debtor authenticated a security agreement describing the collateral, whether the debtor authenticated a security agreement describing the collateral is irrelevant because the collateral is in the possession of the secured party pursuant to the debtor's security agreement. The warehouse company issued negotiable documents of title representing the goods, and these negotiable documents are in the possession of the secured party. Also, value is given when the Worldwide paid for the parts, and the debtor has rights in the collateral use of those components in its manufacturing process. So perfection of a security interest in the goods has also occurred. Possession of the negotiable documents of title is a means of perfecting a security interest in them. Furthermore, perfecting a security interest in the negotiable documents is a means of perfecting a security interest in the goods they represent, while the goods are held by the issuer of the documents. So therefore, answer B is incorrect because negotiable documents of title presenting the goods are in the possession of the secured party pursuant to the debtor's security agreement. Possession substitutes for the requirement of an authenticated security agreement. And so answer C is also incorrect. The security interest is perfected by possession of negotiable documents of title representing the goods. And answer D is incorrect because Worldwide security interest in the goods will be perfected for a period of 20 days without filing after making them available to the debtor for processing or otherwise dealing with them in a way preliminary to their ultimate sale or exchange. So therefore, answer A is correct. Worldwide has a security interest in the goods that has attached and is perfected. That interest will be sufficient for 20 days without filing. In the event that they don't actually file the security interest in 20 days, if there's a perfected security interest filed after Worldwide, then Worldwide will be considered an unperfected security interest. Okay, so problem 25 deals with priorities and unperfected security interest. Specifically, the definition for priorities is a legal preference or precedence. When two persons have similar rights in respect of the same subject matter, but one is entitled to exercise his right to the exclusion of the other, he is said to have priority. And more specifically, we're looking at unperfected security interest and whether they're subordinate to anyone else. The question asks, Cross has an unperfected security interest in the inventory of Safe Inc. The unperfected security interest gives him what? So the rules for unperfected security interest in subordination states that a perfected security interest in the same collateral, rights of a lien creditor, and lessee of goods. So it's subordinate to these three areas. And under lessee of goods, if the lessee gives value, takes delivery, and has no knowledge of the security interest. So through that, certain interests have priority over unperfected security interest. Included are the rights of a lien creditor, as we mentioned, and the lien creditor takes the property subject to any security interest perfected before the lien attached, but its rights are superior to any security interest perfected after the lien attached. So answer A is incorrect because a subsequent creditor who perfects its security interest will have priority over an unperfected security interest. And answer C is incorrect because perfection has no effect on the relationship between debtor and creditor. So it makes no difference whether it was perfected or not. The relationship in the debt that existed between debtor and creditor remains the same. And answer D is incorrect because inventory is one type of collateral in which a security interest can be perfected by possession. So therefore, answer B is the correct answer. The unperfected security interest is subordinate to lien creditors of Safe who become such prior to any subsequent perfection by Cross. Okay, so problem 30 also looks at exceptions to the general priority rules. The question is asking, with regard to a prior perfected security interest in goods for which a financing statement has been filed, which of the following parties is most likely to have a superior interest in the same collateral? If we're looking at item A, a buyer in the ordinary course of business, other than a person buying farm products from a farmer, takes the goods free of any security interest created by the seller. This right is extended to the buyer regardless of whether the security interest is perfected or the buyer has knowledge of its existence, unless the buyer specifically knows the purchase violates the interest. So therefore, answer B is incorrect because the subsequent bona fide purchaser will not have priority over a prior perfected security interest in consumer goods if the interest was perfected by a financing statement. But she will have priority over any interest that was perfected automatically upon attachment, such as in the sale of consumer goods with a purchase money security interest. A buyer of consumer goods from a consumer takes free of a security interest if he or she buys without knowledge of the security interest, but knowledge is imputed to the buyer if a financing statement has been filed for value for consumer purposes and before the secured party files. and therefore answer C is incorrect because a trustee in bankruptcy has priority over any unperfected security interest or any security interest perfected subsequent to the filing of the petition for relief, which is the petition for bankruptcy. However, the trustee's rights are subordinate to those of a prior perfected security interest. And answer D is incorrect because a lien creditor has an interest superior to an unperfected security interest or to a security interest perfected after attachment of the lien. So therefore, answer A is correct because a buyer in the ordinary course of business, other than a person buying farm products from a farmer, takes the goods free of any security interest created by the seller. Okay, so problem 37 also deals with exceptions to the general priority rules. A fixture is a good that has become so related to a particular real property that an interest in the fixture arises under real property law. So the question is asking, perfection of a security interest in a fixture usually requires. So fixture filings must include, indicate that it covers fixtures and that it is to be filed in the real property records. It must sufficiently describe the real property, and it must provide the names of the record owner, which is the property owner, if the debtor has no recorded interest in the real property. And to really understand how this question applies, you must understand what a fixture is. So for example, an individual owns a piece of land and owns this building on the land. Someone else comes in and renovates the building and adds items to the building that are necessary for them to perform their business. Those items, such as, let's say, a boiler unit or an air conditioning unit, specific types of light fixtures or coolants, those items become fixtures. But someone in the ordinary course of business who walks onto this property would not recognize that part of this is owned by one person and part of this is owned by another. And therefore, fixture filings must indicate that it covers fixtures, and it has to be filed in where the real property records, so where the real property deed to secure debt or mortgage or the deed to secure ownership of the property is filed. It must sufficiently describe the real property where the fixtures are located and provide the name of the property owner. And this puts people on notice that if they're coming to buy this, let's say the seller is not acting in good faith, the person who owns the property and owns the building, and he indicates to a buyer that he owns everything there, when in fact part of those items that are attached to that building are not owned by the property owner. An example is where they're talking that it has to be filed where the real property records are filed. For example, let's say the person who renovated the building and is running the business in the building bought all of those fixtures in Atlanta or Macon. Those are different counties where the property actually sits if the property sits in Baldwin. So therefore, they have to take that fixture filing, the person who sold the items to the person who's going to put them in the building. That company has to take those fixture filings, and besides, if they sold them in Bibb County, they need to file them in Baldwin County where the property sits. And within that fixture filing that's filed, they must show the property owner. That puts everyone on notice who might be looking, let's say, through a title search or trying to determine if they want to buy that property, that there are fixtures attached to the building on that property or attached to that property in some way that actually belong to somebody else or that are under a security interest. So if we look at the problem in question, answer B is incorrect because a filing must be in the real estate records, and answer C is incorrect because a purchase money security interest in a fixture is not perfected when it attaches unless it is a consumer good, and answer D is incorrect because a dual filing is unnecessary. So therefore, answer A is correct. Perfection of a security interest in a fixture usually requires filing of a financing statement in the office where a mortgage on the real estate would be recorded. Okay, problem 42 deals with default and remedies, and specifically it deals with proceeds of disposition. The question asks, in what order are the following obligations paid after a secured party rightfully sells the debtor's collateral after repossession? Okay, so the debtor has defaulted on the security interest, and the creditor has stepped in, taken possession of the property or the items, and have sold it. So what is the requirement for proceeds of disposition after selling? First of all, the reasonable expenses of repossession by the creditor must be paid. The secured debt, which is the debt held by the creditor, must be paid. And then any subordinate security interest or other subordinate liens will be paid. So that's the order in which proceeds will be dispersed. So items in question, answer C is correct. So the secured party's reasonable expenses, sales expenses in item 2 would be first. The debt owed to the secured party in item 3 would be second. And the debt owed to any junior security holder, which is also considered a subordinate security holder, would be third. Now, it may be that there's not sufficient money to pay the debt owed to any junior security holder. In that case, the distribution still remains the same, and the debt owed to the junior security holder is unpaid, and they would have to go after the debtor in a different method because the items have already been sold. That concludes all the problems for this section on secured transactions, and believe me, I know this area is very complicated. It's complicated to law students and it's complicated to attorneys. So do the best you can. We'll have another PowerPoint on negotiable instruments, and then the quiz is on both of them, and you can use all of these PowerPoints and your text to help you complete the quiz, and you have 2 attempts to complete the quiz to help you learn the material. I suggest that you go through both PowerPoints and do the quiz prior to trying to work on the legal issue. Thank you.